protection of the law. And if you're just joining us, thank you. My name is Shaffer. I'm an attorney. And we are talking about what the definition of abuse is under the law. And it is not just physical abuse. It could be psychological or emotional abuse. Well, what is that? What does that look like? Psychological, emotional abuse can look like many different things. I'll give you some examples from cases that I've dealt with. So I deal with a lot of immigrants as an immigration lawyer. And one of the things we see, unfortunately, very often is that an immigrant, the U.S. citizen or permanent resident spouse, will threaten to have the immigrant spouse deported. Now, spoiler alert, there's no number to call. I get that question a lot, to deport somebody. It doesn't exist. But it's a very serious consequence to somebody, and it can be very psychologically damaging. But it's usually not that alone. When someone talking down to you, cursing at you, making you feel bad, controlling behavior, taking your phone away, cutting you off from family and friends. When you're talking about psychological and emotional abuse, there's usually a totality of the circumstances. We look at the whole picture of the relationship about what's going on. And unfortunately, more often than not, this psychological or emotional abuse can lead to physical abuse. So the goal with the law is to protect you before it gets to the physical abuse. So you don't have to feel like, well, I'm not being treated right. I need help, but he's not hit me or she's not hit me. I can't get any help. That's not true. In fact, we have a lot of clients who come in and they come in and they know something's wrong with the relationship, like something's off. And if you're just joining us, thank you. We're talking about what abuse is under the law. And we just went over that it doesn't have to be physical abuse. It can also be emotional and psychological abuse. And I'm giving some examples of it based on my experience. And I'm explaining how a lot of clients, they come in, they know something's wrong with the relationship, that their spouse isn't treating them right, but they don't say they're victims of abuse. They don't realize they're victims of abuse. And it's not until we start talking to them and they start to explain the relationship that we'll say to them, hey, wait a second, you realize that you're being abused. And it is a very difficult thing for somebody to come to terms with and accept. But it's really important to recognize it, because that's the first step for you to be able to help yourself. And some people, it can take a really long time, and that's understandable. And part of that reason is that you may live with your abuser, you may have a child in common with your abuser, your immigration status may depend on your abuser, so you have all of these things pulling at you to stay in a relationship. And one of the reasons I wanted to do this today was to let you all know out there that there are options and there are a way around this. So let's talk about what type of protection is out there. And this will bring me to one of the questions I received, where someone explained to me that she's been being beaten by her boyfriend. They live together, and she's called the police. Welcome. If you're just joining us, I'm Amanda Shaffer. I'm an attorney at the Shapiro Law Firm. We're talking now about what type of protection is available if you're a victim of abuse. We went over what abuse is, that it's not just physical abuse, but it's also mental, emotional, psychological abuse. You don't have to be physically hurt to seek protection under the law. So if you need protection, what are your options? And as I was saying, I had a question from someone explaining to me that their boyfriend who they live with has been abusive. They called the cops. The cops think that she's crazy and they won't help. But he comes home and he still beats her. What does she do? Well, the good news is you don't need the police. The police, we'll talk about, there's 3 different avenues you can go, where you 3 starting points, and the police is one of them, and that's the criminal avenue, but it's not the only avenue. And, you know, the police are supposed to be there to help you and protect you. And I've heard this a lot more from men who have dealt with the police, but a lot of men have come to us and said, I called the police and they didn't believe me. They didn't do anything. So, and unfortunately that happens, but we can still get you protection. And the way we do that is we go to family court or civil court. Now, with the civil court option, it's usually only going to be in connection with another proceeding like a divorce, or it could be something else. That's much rarer. Family court is your best bet, but in order to be in the family court, the person who's abusing you has to have the requisite relationship. They have to either be your spouse, your partner, someone you're related to by blood, like a parent or a child or a sibling. It could be someone you have a romantic relationship with, someone you live with, but it's not going to be a stranger. Usually not just a friend. We got a question. Kristen asked, what resources can I share for people quarantining with an abuser? That's a great question, Kristen. I have some resources already up on the event page. I will list some more, but there are hotlines out there. If you're in New York City, Safe Horizons is a great one. The National Coalition Against Domestic Violence, I think I got that acronym right. But I will make sure that I provide all those resources again and more. And that's one thing that's important to note, that there are so many resources. These resources, they do everything from find you a place to live, change your locks, find you a lawyer, help you file a petition, give you some cash assistance, childcare. So you're not alone. And there are plenty of things you can do. And going back to these are routes to get protection. I was saying in family court, you have to have the relationship. It's generally speaking a blood relative related by blood or marriage, or you live with the person. If not, you're going to need to go to the cops or possibly go to civil court. Now, those are the three avenues that I'm talking about. We're going to focus mostly on the family court aspect, because in the criminal aspect, the abuser is going to get arrested, and you're most likely going to be given what's called a temporary order of protection, and some people know that as a restraining order. But this temporary order of protection, you're going to get the same thing in family court. The biggest difference is that when you're in the criminal court, you're not a party to the case. You're the victim. When you're in the family court, you're the petitioner. You're the one filing the petition. It's called a family offense petition. And that means you're in control. You're in the driver's seat. When you're in criminal court, you don't really have a say. You might not even know what's going on in court. The DA is not even required to tell you when court is. I've had clients come to me and not know that a plea deal was accepted because the DA didn't tell them. You also don't get to choose if you're going to press charges or not. People ask me that all the time. I want to drop the charges. I want to press charges. The only person or the only entity that can press charges is the district attorney. And when a victim of domestic violence goes to police and says, I know I called you, but I'm not really in danger. I don't want to testify. You can drop the case. They often do not drop the case. And the reason is because they're worried about undue influence by the abuser. If this is a person you live with, you're getting pressured to drop a case against. So they're very reluctant to DA to drop the case. So even if you really were like, it was a heat of passion that I called the cops, I'm fine now. Once you get that criminal proceeding started, it's no longer in your control. And of course, you have some very serious consequences with arrests. That in the family court aspect, although there is a possibility of jail time, it's much rarer. So let's look at the family court option. The reason that's a great option is for a few reasons. Number one, you don't get the cops involved. Number two, if you can't afford an attorney, you're given an attorney. When you're a victim in the criminal court case, you don't get an attorney assigned to you. You're, of course, welcome to hire your own attorney to represent you as a victim. But again, what the victim wants isn't the DA doesn't have to take into consideration necessarily. So when you're in the family court, you have an attorney assigned to you, and you're in the driver's seat. So it starts by filing a petition called the Family Offense Petition. You go to court. Now, here's one thing that's a negative. When you're dealing in the family court, you're more likely to see your abuser because they're going to go to court too. You both are required to be there. Criminal court, you're not going to, unless you're testifying at the trial, you're not going to court unless you want to. So there is the increased risk of that contact, but the family court does take steps to separate people, especially if there's someone who's really dangerous. And I'll get into a little bit more about what it's like going to court in family court for these orders of protection, but I want to explain what an order of protection is. As I said earlier, an order of protection is, so a lot of people know it as a restraining order. In New York, it's called an order of protection. And there are two main types. One is called a refrain from, and one is called a stay away. The difference is, with a refrain from, the order is going to say refrain from committing a crime against a person. A stay away is where you can't go to the person's house, you can't go to the person's work, you have to stay at least 100 feet, those types of conditions. So this full stay away is much, much stronger. And hello, Tanya. Thanks for joining us. And with the full stay away order, if you see the person across the street, you can call the cops, they're going to get arrested. If you butt dial somebody and there's an order of protection, you're going to get arrested. I actually had that happen to a client of ours. His ex-girlfriend had an order of protection against him. He didn't take her out of the phone. He butt dialed her. Cops came and arrested him, and they said, I don't care. If it was a mistake, you should have taken her out of the phone. So both of them are pieces of paper, and I want to focus on that for a second. Ultimately, an order of protection is a piece of paper. So when you're seeking protection, how much protection can you get from that? Well, it's going to depend on the situation. And this is a good time for me to mention that if you are in imminent danger of bodily harm or death, or your child is, or a loved one, you call the police. You call 911. That is the best route for you. There's no question, because that person's going to get arrested and they're going to get out of your house. Now, when you go to court the first time in family court, you're often, as long as you're going without your abuser there, you're telling the judge your side of the story, why you need protection, and generally speaking, they're going to give you the temporary order of protection, which is good until the next court date. What that ends up doing when you have a stay-away order, you might live with your abuser. Now your abuser can't come to your home. Your abuser has to leave. And that's a very powerful thing. If you have a child, there can be a child in common with the abuser. There might be there might be some type of supervised visitation or some type of custody, like temporary custody order. To make it clear, it could be a temporary child support order as well in there. But ultimately, it's going to give you the leverage to be safe in your own home, and it gives you the peace of mind that if this person comes near you, the police will arrest on site. You show them the order of protection, they arrest on site. Now, at the same time, again, it's just a piece of paper. So I've had situations where clients have said we're scared to serve the petition on a person because they had a gun or something like that, or some type of weapon. Now, it's standard in these orders of protection that any weapon legally or illegally owned should be surrendered In New York City, they're never legally owned. So if you know the person has a weapon, they're supposed to surrender it. But again, they're not going out and necessarily taking the gun away. So you have that risk, and that's why if that risk is out there, you're welcome, Genevieve. If that risk is out there, you call the police. And that's very important to do. So basically, the orders of protection are not the only thing that you can get out of the family court. If you have a child in common, as I said, not just in the temporary order, but in a final order, there could be visitation, there could be child support, there can be parenting classes ordered, anger management classes ordered, substance abuse classes ordered. That those three things are true of, well, not so much necessarily the parenting class, but there are the other two in criminal court. They can order anger management, substance abuse classes as well. And let me see what else we can have here. There's some types of restitution that can get paid, which means you're getting money. Although I haven't seen that too much in family court, that can also be a part of a criminal court case as well. So and then of course, when it comes to consequences that your abuser can face in family court, other than an order of protection, there can be potential jail time. Usually, they're reluctant to do it, the judges, unless there's a violation of an order of protection. So whether it's a temporary or a final, you get the order of protection, and you have a stay away, let's say, and you get called by your abuser. And you might not want to call the cops because, you don't want to do that, for whatever reason. But you can still file a violation petition. And if it's an egregious violation, the judge at many times will order the person confined. It can't be more than 6 months, and it's rare, but they can also, the judge can transfer it to the case to criminal court. In fact, you can have a case in criminal court and a case in family court going on at the same time, and technically have 2 orders of protection against the same person. A lot of times, they'll cut one of those off, but the criminal court refers it to the family court sometimes. Generally, when there's a child involved, they want you to get into family court because they're going to have to deal with the custody and visitation. But it can be going on at the same time. And it can go from family court to criminal court, especially if there's something really aggressive or egregious about the person's behavior, because one thing that you have to do when you file a family offense petition is you have to list a crime that's been committed by your abuser. And there's only a limited, it's not every crime in the penal code that we can have. Just to give you an idea, assault, harassment, strangulation, sexual abuse, murder, although murder I would imagine would get moved to a criminal court case. I guess it would be attempted murder if you're filing it. But the point is that it's not every crime, and just like not every person can be in family court, not every crime that's committed, but essentially you're saying to the judge, this person committed a crime against me and I need protection from them. And as opposed to in the criminal court case, where you have to prove, not you, the DA has to prove guilt beyond a reasonable doubt, which means like 99.99999% this person's guilty. In the family court case, it's called a preponderance of the evidence standard, which means you only have to show 51% that you're right. And that's big in a lot of these domestic abuse cases, because what we often see is a lot of he said, she said. What I mean by that is you don't have any physical evidence. You don't have, maybe you'll have text messages and emails, but that's not the best physical evidence. You're not gonna, maybe you'll have a recording or something, but you're not gonna have real physical evidence. It's a lot of times it's just you're saying this person did this to me, and this person says that I did this to them, and it goes back and forth. So you just have to be technically believed more than your accuser is believed by the judge. And when that happens, you're going to get a final order of protection. Those can be in family court up to 2 years. They can actually go up to 5 years if the behavior if it's really aggressive. It can be renewed indefinitely. You do have to file a new petition to get another order of protection. You know, generally speaking, if the person leaves you alone for 2 years, it might be difficult to get a judge to issue another one, but it depends on the situation, and it's certainly possible and certainly happens. So there are pros and cons to going both routes, and it really is going to depend on what's going on in your life, what you're looking for, and how awful the behavior is. You know, like I mentioned earlier, if you are dealing with physical abuse, I always recommend you call the cops, because especially if someone you love is harming you, it is not going to get any better. So if it escalates, you're going to be in a bad place. So you really need to take action immediately. You call the cops. In New York, the cops actually are required, which I didn't know for a while, they're required by law to arrest somebody when there's a domestic violence call. Now, some of you watching may have called the police, and like I was talking about the question I had earlier, where someone had called the police and they didn't arrest the person. I've had people tell me I called the police because I was being abused, and then I got arrested. That happens. I've heard that happening too. But technically in New York, the abuser is supposed to be arrested. So when you're in that imminent danger, that's what you do. If you're not, you can still go to the police if that's what's best for you. But if you don't want to, and there are very good reasons why people don't want to, doesn't mean you can't get protection. And that's where the family offense petition comes into play. And if you weren't here earlier, I mentioned that if you cannot afford an attorney in family court, you will get an attorney assigned to you. And that can be really helpful for people, because in the criminal court, you do not get a free attorney if you're the victim. So let's go back to the process involved to get this final order of protection. What is this going to look like for you? And what would it look like in the criminal versus the family? Now, in the criminal court, like I said, you are not going to have much say. You're not going to, depending on the DA, you might not know what's going on. And eventually you might just get mailed a final order of protection. There might not even be one when you really need one because of some plea deal that you weren't privy to. The family court, it's a little different. So in the family court, you're in the driver's seat, and you go to court, you file a petition, you generally get a temporary order of protection, which is good until the next court date. And then at the next court, you serve the abuser, which is going to trigger them having to stay away from you or refrain from harassing you, committing crimes against you. If it's a full stay away, they're going to have to leave. If you have a child in common, there's going to be at this point a presumption that they should not be around this child. So the child will stay with you. Supervised visits can be put into place. And this is all temporary until the next court date. It gets extended until the case is over. And it's over if you withdraw it. It's over if you settle. And I'll talk about a settlement shortly. And it's over if the judge makes a decision on the merits of the case. So either grants the order of protection or denies the final order of protection. When you go to court, you're hopefully everyone has attorneys because it makes things a little bit easier. But you want to, there's always a settlement talk that's going to go on. There's not too many things to settle with when you're talking about a family defense petition. If you're talking about this in the context of a divorce, sometimes there's leverage on one side. We have a question from Nathan. Are you notified when the order of protection is served? Yes, you are, and you should be. Sometimes the judge will order service by sheriff, and if you have an attorney, I mean, I've served plenty of people. The attorney will arrange the service, and I always notify my clients. But that's a great question because it does trigger all these issues. But the sheriff is supposed to tell you the second that they're served. And I've had clients who get emails from the sheriff to let them know. And that's what we need to show the judge when we go back to court, to show that this person was notified of the court date. Because if they don't show, there's some serious consequences. And that does bring me to another point I wanted to make. I was talking earlier that an order of protection is a piece of paper. Well, I kind of undersold it because it is a piece of paper, but it's a powerful piece of paper because what it says on there is that if you don't comply, a warrant can be issued for your arrest. And that's really powerful. People see that, they get scared, and people comply. Not all people, and that's why I go back to it's a piece of paper, but it does have a very powerful effect on a lot of people. So let's get back to going through the process. So you go and you have this negotiation. Generally, as a lawyer, I try to do, if I'm representing a victim, I want this to be over. My client wants it to be over as soon as possible. He wants to get protection and move on with their life. So we don't need the abuser to admit fault here. We just need the abuser to accept the order of protection. So a lot of times it's a negotiation saying, look, if you just accept the order of protection, sign the agreement that you will stay away, and it has the same force as if the judge ordered it, the judge will sign it as an order. You don't have to admit fault or guilt or anything like that, and everyone can go their separate ways. And sometimes that's accepted and sometimes it's not, because there can be very serious consequences that comes with having an order of protection. For example, if you're an immigrant and you're trying to get your green card, you might not want an order of protection. If you work around kids or something, in that type of capacity, that could show up on a background check. So it's not always so simple that someone just wants it, and sometimes it's just a stigma and knowing that it's there, and that how easy it is to get arrested, even with an accidental violation. Excuse me, let me just get some water here. And by the way, if you have questions, please feel free. You can also, if you want, directly message me if you want to ask me a question anonymously. I'm happy to answer. So, assuming the negotiation fails, what's left is trial. Now, it's not exactly like Law and Order or one of those TV shows where you're not going to have a jury. It's just going to be you, the abuser, your lawyer, their lawyer, the judge, the clerk, the court officer. It's a closed court proceeding. The public can't come in and view. You're not even entitled to have your family there unless the other side agrees to it. So it's very private. But there are the standard rules of evidence in place. You can bring in witnesses to testify. There's direct and cross-examination. Both sides get a chance to present their case. And at the end of it, there's going to be a decision by the judge. And generally, the judge is going to grant or deny the petition. They grant it, you get a final order of protection, which will be either 1 or 2 years. They deny it, you can always refile if you have additional allegations. So, one second, let me get a little bit more water here. This whole process is usually a lot slower in the family court than the criminal court. In both, you're going to get that temporary order of protection very quickly, and it's going to have the same effect as a final order of protection. And that's the good news. So you don't have to wait a year plus to get something, to get some type of protection and sense of safety. But when you're in the family court, especially in New York City and Westchester and Rockland, the courts are pretty booked up. So there can be 6 months plus between hearings. And especially with the coronavirus right now, it's, things are backing up even more. I have a family offense case going on right now 3 years, which is absurd. And there's all sorts of reasons. It's not just a family offense petition case. There's child custody issues involved too. There's separate petitions filed, which happens sometimes. But while, like I said, they're always extended, the temporaries, until the next court date, so you're going to be protected while you're there. But what ends up happening sometimes is that the abuser's behavior might look more attenuated from the present, or it look like, well, they may have did something not great back then, but they stopped. Well, they only stopped because of the temporary order of protection. They don't want to get arrested. And that's the point we have to stress to the judge when in issuing the fine. Obviously, if they violated the temporary, that's not going to look good either. So you have to be prepared that you might be going back and seeing this person over and over and over again. If you don't live in New York State, but you need a protection from New York State, or you live in New York and you're unable to make it to court because of work, a good reason, not just work, there is a possibility to do a telephonic appearance, which I have a number of clients right now that we do that with. I don't love it unless it's necessary. And the reason is that the person on the telephone cannot really hear what's going on as well. And the technology isn't great. They can't see. And, I often have to go over everything with the client afterwards because I want to make sure that they know what's happening. So if you can be there in person, it is highly recommended, but there is that option for you out there. So again, at the end of the day, you're going to look for this order of protection, and that can come with some other things too. You may be able to get attorney's fees. You're more likely to get attorney's fees in a violation than an initial order of protection. But we always request them, of course, and if the victim wins, if the abuser has the means, it's possible. There can be a surrender of the guns or other weapons. Another thing that I forgot to mention earlier is that an order of protection can help not just you, but you can file on behalf of a minor child or yourself and a minor child and an animal. I have a client right now who the abuser threatened to throw the dog out the window. And that's horrible. And that's a huge part of the petition and a very serious crime. So it can be a stay away order not just from you, but from your child and from a companion animal. Companion animal, dogs, cats, I'm sure horses. I don't know how much further that extends, but I've never been asked that, but we can always look at that. So other things that an order of protection can help you with is, in New York, the law just changed to make it easier. But if let's say you live with the person, you have a lease together. Well, if you want to move out, or this person moves out because you filed a petition or they got arrested, you might not be able to afford your lease. And, you know, there's very strict early termination clauses in the lease. So it used to be, in order to get your lease terminated, you had to have a court order. They've loosened that restriction immensely this past December. And what the change does is that there has to be a credible allegation when you ask your landlord to terminate it. A lot of landlords don't know about this new change or don't want to acknowledge the new change, but you don't need the court to order it. It helps. You might need an attorney to explain it to them. The change in the law also says that they have to treat the termination as if you carried your lease out until the full term. So they have to return your security deposit within a reasonable period of time. They can't hold it. You have a 2-year lease. You terminate a year early. They can't hold it for a year. They have to send it back to you. Another thing that they can do is, I've said, transfer to the criminal court, supervised visitation. Another big one. Getting your stuff back, or your abuser coming back to get his or her stuff. So again, this is something you might not think of when you call the police at first, or when you go and file a petition, or when you run away from, God forbid, from your home. You might not realize, well, I have all my stuff there. I live there. How am I going to get my stuff? I can't go back there. I'm going to get abused. Well, what the judge can do is put in the order saying that on this date and this time, the police are to accompany you home or accompany your abuser to go get your stuff. So there are ways around that, and it's not always clean because people argue over whose stuff is whose. I've had clients where they went to go get their stuff and everything was gone. But there is that option if you didn't think of it in advance or couldn't think of it in advance, to at least have some way to go back there or to allow your abuser to come back there and get his or her stuff. I had a client once who kept bringing bags of the abuser's items to court, and the abuser did not want to take it, but then kept complaining that he couldn't get his stuff. So the judge was like, you can go back there and make sure you got your stuff, but why wouldn't you take your stuff? It was quite an odd situation. And again, anyone, if you have any questions or you're just joining us, please feel free to ask. We just went over really the crux of what an order of protection is, what it can do for you, and how you get it. If you missed that, I believe you can rewind this thing, but I'm happy to answer any questions. So, we talked really about the basics of the family court aspect, and what I want to talk a little bit more about, which will also bring us into the civil court aspect as well, is what happens when you have a child in common with your abuser. How does it affect it? How does it affect divorce? How does it affect child support? How does it affect custody? Now, I'm not going to go, I'm going to give you a general overview because there's a lot to pick apart there. So, of course, if you have a child in common and this person's abusive to you, they don't have to be abusive to the child also, although many times that is also the case. It's going to have a major effect on the judge's decision with child custody, with visitation. Child support, it's not. Child support is kind of separate. It's really just based on a calculation of income. And one thing I hear a lot from clients is they say, I don't want to pay child support because I'm not allowed to see my child. Well, they're not actually tied together. The child support is money is the child's right, the child's money. The child has a right to the money, not the parent. So even though you should not be denied your visitation rights, and that's not okay, and there's things you can do about it, it doesn't mean you can stop paying child support. So I always like to make that very clear. But what it does affect is custody and visitation. One thing the judge can do, I mentioned earlier, parenting classes. Very, very important. Parenting, anger management, substance abuse classes, all of those things. They can be very helpful. I also forgot to mention earlier, mental health counseling, therapy. That can also be done. In a divorce, there can be what's called a forensic evaluation order, where there will be either a psychiatrist or psychologist, social worker that's assigned to the case that meets with each parent individually, and then the kid with the parents, and then the kid individually, depending on the age, and then writes up a report about how everybody is and what the parenting skills were like, and if this happens in a custody battle, which parent the custody should go to. I just had a question about what about people that are not legal and afraid to report it. That's a great question. Anyone can report domestic violence. It does not matter what your immigration status is, and you should not be afraid to. Now, I can't speak for the entire country, but I can speak for how it is in New York and a lot of states, that the cops, they're not supposed to in any state care about your immigration status. They're supposed to just protect you. In New York, they just protect you. They're not reporting you. They shouldn't be asking you about your immigration status at all. It's not relevant. But you should never be afraid. The police, the New York Police Department, the NYPD, the New York State Troopers, they're not here to patrol immigration. They're not immigration enforcement. They're the police. They're not related at all. And in fact, right now, the New York and the federal government, they don't even get along. So the New York police have never been like that to turn on an abuse victim. So you shouldn't be worried. And if I can get to it today, if not, I plan my next topic to talk about specifically for immigrants, what type of protection they can get if they're in the situation in terms of obtaining legal status. But I want to get back to right now, excuse me, to children in custody, because that I think I think a lot of people are unaware of and worried about, because and one of the reasons they're hesitant to start any of these processes because they don't want to lose their child. And one thing you see a lot of here is retaliatory filing. And this is something that you're not going to really see in the criminal court, but in the family court. I file a family offense petition against you saying you are abusive. And to get back at me, I'm going to turn the tables. You're going to file it against me and say, no, you're lying. You're not, I'm not the abuser, you're the abuser. And then you have these competing cases going forward. And I would say that actually happens more often than not. The abusers like to turn the tables on the victim. It's part of that cycle of abuse. So again, I've been trying to highlight some of the pros and cons to each avenue, and that is something, eventually, the truth comes out, but that is very common. And not saying that every retaliatory petition isn't real. I'm just saying there's a real chance of it happening. So if you do have a child in common with someone, then when you file it, the child can be named on the petition too. And generally, it's because either the child has personally been harmed or you're worried. In New York, if you hit somebody in front of a child, that's considered child abuse. They don't have to actually hit the child, or child neglect. And that can trigger child abuse and neglect proceeding. In family court, it can trigger criminal charges as well. So child abuse does not necessarily mean the child has to be harmed personally. And getting back to when I started talking about the different types of abuse, the same is true with children in that it doesn't have to be physical violence. In fact, like I said, it doesn't even have to be directed at a child, depending on the situation. So what the court can do is issue temporary custody orders so that the abuser doesn't have access to the child, and then can issue supervised visitation. And there's different forms of supervised visitation. There's one where you actually go to a place and you're monitored the entire time by a professional. Generally speaking, it's paid for, and it's like an hour at a time. Those don't last too long. They kind of just want to make sure. They're usually is in conjunction with parenting classes. There's another type of supervised visit where you have a mutually agreed upon third person. It could be a family member, it could be a friend who's always there during the visits. And this can go on for as long as it needs to go on. And it can be reviewed, of course, by the court and changed to unsupervised visits. But when you have credible abuse allegations against someone and a custody battle, the court is going to weigh that very heavily when in determining who should have custody. And we see a lot of times where orders of protection or family defense petitions are filed by a spouse when there's not really credible allegations to get a leg up on getting custody. That does not go over well with the judge, it's the truth comes out. As I said, yes, people can lie under oath, but ultimately, I've never had anyone legitimately lie about that I know of, at least, about physical abuse. Generally, people just kind of trump up the psychological abuse and the threat to them. And I've had it backfire on clients. The judge sees it as they're just trying to withhold the child. And when we're talking about custody, we're talking about a totality of the circumstances. Who should get custody? The judge looks at the best interest of the child. So domestic violence on one side is going to weigh really heavily. But it's not just because you have a threat of an allegation of domestic violence doesn't mean you're getting custody and that's that. It's not even close to that simple. So you want to be very careful if you're not telling the truth, and I don't recommend you doing it if you're not telling the truth. It's going to actually harm your child a lot more than you think it's going to do. But like I said, your abuser can get help, supervised visits. I have clients often say to me, I don't want the father or the mother seeing the child because of how abusive they've been, ever. Unless the person gives up their parental rights, that's probably not going to happen. There can be lots of supervised visits, but generally speaking, you have a right to see your child. And the person who has custody is required by law to encourage a relationship no matter who that other person is. Repeat offenders, repeat abusers, substance abusers, eventually, yeah, the judge is going to say you should not be around children. But I've had some bad situations where the judge, I've had a father disappear for 10 years, was not very nice. Some abuse in the relationship early on. All of a sudden, he's paying child support, wants to see the kid, and mom is like, I don't trust him. He doesn't, the way he treated me. And the judge said it doesn't matter. That's his father. He wants to be in his life. He gets to be in his life. So just because you call the police and get somebody arrested, just because you say that you were abused, it doesn't mean they're going to not be able to see their child. It's a very important thing to keep in mind. On that same note, when we talk about divorce, how does it affect that? There is a ground of divorce that's based on cruel and inhumane treatment. It's Domestic Relations Law, Section 170, subsection 2. You do not have to file divorce based on that ground in order to make an allegation of domestic violence related to your divorce or child custody. And there are reasons why you want to and why you don't. One thing is it's going to most likely preclude an uncontested divorce, because nobody wants to have a divorce that says they're an abuser. And it's just not necessary, but it can certainly occur. And a lot of times you end up agreeing on the ground of divorce. If you're disagreeing, it's hard to get someone to agree to that ground. And it doesn't have effect on spousal support, child support, custody, because what's going to have that effect on custody is the actual allegations and an order of protection. So, and splitting up of assets, it doesn't have an effect on. And on that same note, when you're talking about splitting up of assets, spousal support, as I said earlier, child support, none of that is affected by credible, proven allegations of domestic abuse. That's all separate. So unlike the child custody and visitation rights, when you're talking about monetary value, you're welcome. I'm glad you guys are finding this informative. And please ask questions if you have questions. I'm happy to answer them. We're going to talk a little bit more about the divorce and any other collateral issues that can occur. And then if you guys have any other questions, you let me know. So the divorce is separate in that aspect, but it's all going to happen together. So when you have a trial, you're going to most likely have the trial on all the issues at once. You might resolve spousal support, child support, splitting up of assets, but then still have these domestic violence issues and custody issues to deal with. That happens too, and then you just have a trial on those issues. So that basically covers how the effect on divorce. So I also want to just talk a little bit about other collateral issues involved when you're dealing with domestic violence. And we've touched on a lot of these already, but I want to highlight them. So we talked about if you live with somebody, you share a home together, someone's not going to have a home if you end up getting an order of protection, or you decide you're just leaving the relationship. So who gets the home? Well, if you have a child in common, a lot of times the person in custody of the child gets the home. Not always. But you have a right to leave the home. You have a right to have your lease terminated if you rent, and get your security deposit back timely. You have a right to go get your stuff. Your abuser has the right to go get his or her stuff if that's the person who left. But the other issues that can also occur is related to mental health. I always recommend that my clients seek counseling when they're dealing with domestic violence. It's incredibly difficult to deal with and traumatic. If there are children involved, I recommend the same thing. Money can be an issue too. You're talking about someone maybe you financially depend on, and now all of a sudden you don't have that financial dependence. And you might stay at your home, and now your abuser knows where you live, and you're terrified. Even you have this piece of paper, great, but they know where I am. They want to come over here and hurt me. They're going to come over here and hurt me. There's ability to change locks, relocate. So there's a lot of different ways you can get help. And I mentioned earlier that I already have on the event page some of these resources available. I'm going to list them again. But these places will help you get all of these things and more, and really get your life, get back on your feet. Why is it having trouble playing the video? I don't know if you guys can hear or see me anymore. It says that we're having trouble playing this video. That's lame. Hopefully you can still hear and see me. Okay, well, I hear that you can. All right. Good. Well, we're gonna wrap up now. Oh wait, I got a question here. Let's see. I have a friend. Okay, we got an immigration question here. So, a friend and his wife broke up with him, and he filed for the wife's green card before they broke up, and it's been over 4 years, and he doesn't have a green card, and the wife now wants to tell USCIS, which is the immigration authority, that the spouse, she's not involved. So, okay, this is a good question. Thank you, Tanya. We get this one a lot too. This is something I mentioned earlier. It's 7 p.m. here in the city, so everyone's cheering. Let me close the window. Okay. So, in this situation, we have an immigrant married to a U.S. citizen or a green card holder. They're in the U.S. The immigrant is not here in lawful immigration status, or not here, or here on a temporary basis, and the spouse files for their green card. So, after the green card's filed for, but before they get their green card, the spouse, the U.S. citizen or permanent resident, says, "I'm done. I don't want to deal with this, and I don't want to be with you anymore. And now I'm going to tell immigration I'm going to withdraw. I'm going to withdraw my filing." So what can this person do? Well, there's going to be limited options, and I think I'm going to go over this more in detail in my next live session. But basically, if things when a U.S. citizen or permanent resident files a petition for a spouse to get a green card, it's asking the U.S. government to allow this person to remain here permanently because it's their spouse, and it's dependent on the spouse being involved. If things just don't work out, even if you married in good faith, it was real marriage, if you don't have your green card yet, there's not much that can be done. However, if you're being abused, that's a different story. An immigrant who's being abused by a U.S. citizen or permanent resident, spouse, child, or parent, can apply for something called VAWA. It's called the Violence Against Women's Act. That's what it stands for. But it's actually not just for women. It's for men and women. But basically, it's a path to get a green card. If it turns out the reason you can't get a green card is because you're being abused by your U.S. citizen or permanent resident spouse. And a lot of times when clients come in and tell us they're having problems with their marriage, we always ask them to explain why, and we go through and we are always monitoring and analyzing to see if it's an abusive situation. Let me see. He went and filed a spouse abuse case with a lawyer as she thinks he's lies. He went. Okay. She filed it against him, or he filed against her, Tanya? I'm not sure. That's an important question. Because filing family offense petition, one of those collateral consequences I didn't really cover, can be significant if you're claiming to be an abused spouse and trying to get a green card. You don't need to go to court to get the green card that way, but it certainly helps. He filed against her. Yeah, so that's going to help him. So if he was actually abused, and that's why he filed it, then that's certainly going to help him. That's going to be evidence that we submit with his petition to say to the U.S. government, I'm married to a U.S. citizen or a permanent resident, but this person's been abusing me. And you have to prove that you're being abused. You can't just say it. There's different ways to do that. I won't get into all of that right now, but filing a family fence petition is one of them. So you don't need your spouse to get arrested. You can file a family fence petition, and I've had them granted, these petitions granted with temporary orders of protection plenty of times, because again, these cases take so long. Immigration cases take probably even longer, but there's no requirement, there's no specific requirement for a specific document that you need. And Nathan has a question. If the petitioner tries to get the petitioner to violate the order of protection potentially, what can be done? So if the petitioner tries to get the abuser to violate the order of protection, or the person the order of protection is against, what can be done? That's a very good question. And that's a difficult question to answer, because, it depends on what it is. I mean, technically, you're not allowed to contact the person that you're being protected from either. It's kind of a mutual thing that's supposed to happen. Although you're not getting arrested because you texted them, they're getting arrested if they texted you. If you're the subject of the order of protection, and it says you can't contact this person, even if that person reaches out to you, if you respond, you're violating your order. No matter what the reason is. Unless there's some type of exception, there's usually, if you have kids together, there's exceptions carved out. You can contact each other about the kid, but that's it. But essentially, if you violate it, even if you're kind of goaded into it, there's not too much you can do. Now, that's if there aren't dueling family fence petitions. If the person who has the order of protection is actually abusive too, or the abusive one, it could be a part of that abuse. It's a way to control. It's a way to have influence over you and do certain things. So we have to look at it in the full context. If it's the case that your abuser is, if the person who filed the order of protection, the petitioner, actually is trying to just get you to violate it so you get in trouble, and that's part of a bigger picture, then things can be done. Either if there is an order of protection on the other side, filing a violation, filing an order of protection to begin with. But the purpose of the order of protection is not to give one person power over the other. It's to erase that power. It's to make everybody safe, so that it's not to be used to abuse that process. So, if it comes to light to the judge that it's really clear that somebody is trying to get the other person to violate it, then the judge can actually dismiss the case too. I haven't seen that happen yet, because usually, I make it very clear to all my clients, if they have an order of protection against someone, I tell them you do not contact them. There's no reason for you to contact them. And so at least my clients, they tend to listen to me, luckily, and it doesn't get to that point. But the options are, overall, if it's going to probably have to be pretty egregious, but filing your own family fence petition, generally in connection with abuse, filing violation if there is a competing order of protection, and requesting the judge dismiss the case. Tanya had a follow-up question. She has a green card, not a citizen. So we were talking about an immigrant who's married to a U.S. citizen or permanent resident who's being abused. And it looks like we have a question about the difference between the abuser being a citizen versus a permanent resident. In terms of VAWA, it doesn't make a difference. And VAWA, if you weren't here before, stands for Violence Against Women's Act, although it's covers men and women alike. It's the way an abused spouse can get a green card. But under the law, there's no difference if you're married to a permanent resident or a U.S. citizen. However, where the differences come into play is what the potential consequences can be for your spouse. You're married to a U.S. citizen. Your U.S. citizen isn't worried about being deported ever. You're married to a permanent resident. If he or she's arrested, if he or she gets an order of protection, they may be in violation of the terms and conditions of their green card and can be at risk of losing it. So, in a sense, there may be more fear from your spouse if it gets filed if he or she is a permanent resident. So, thank you for that question. That was a good one. So, I do want to get more into the VAWA stuff and what other consequences there are for immigrants in these types of relationships next time, because my voice is going. And we talked about a lot here today. If there's any other questions while I'm wrapping up, please feel free. Also, feel free to contact me after the live ends. You can email me, amanda@theshapirolawyers.com. You can send me a message through Facebook, Instagram, whatever floats your boat. I'm here for you. And really, like I said, I will also post those resources when we finish again. But, I want you to know that you're not alone. There is help out there. And we're here, the law is here to protect you. It doesn't matter what your immigration status is. It doesn't matter how much money you have. What matters is that nobody deserves to live in an abusive situation, and you have the right to protect yourself. And never forget that you have that right. And don't be afraid to seek that help. You're very welcome, guys. I hope you all enjoyed it. I will be back either next week or the week after with our next session. I hope you all join me then. Again, you can always reach out to me. I'm happy to help you. And I hope that you found this information useful. Feel free to share it. And I look forward to seeing you guys again soon.